Afternoon. My name is Paul Chadwick, and I'm honored to serve as the chairman of Men of Melchizedek, or otherwise known as MOM. I would like to kick off our session this afternoon with a prayer that we say at the onset of all of our meetings. In the name of the Father, and the Son, and the Holy Spirit, amen. O Holy Mother Mary, Mother of Priests, who with your beloved spouse, Saint Joseph, during your sojourn here below, did nurture, protect, and provide for the most sacred divine infant, Jesus Christ, the high priest. In remembrance of the joys, the sorrows, the sacrifices, and the sufferings you endured as the Holy Family, we beg you now for your heavenly maternal care for our beloved priests, your priest sons, O merciful Mother, both living and deceased. With great confidence, we beseech you to assist especially those priests who are the most troubled, tempted, discouraged, and suffering. Intercede too for us, O Holy Mother, that we should not forget how our father Abraham reverenced Melchizedek, king of Salem and priest of God Most High, even giving to him a tenth of all he had. With Abraham as our example, let us give constant thanks to God for all the good he has done for us through the hands of our dear priests. And let us never grow weary of giving assistance to all priests in their time of need. For as sung in the Psalms, God has sworn, and he shall not repent. You are a priest forever in the line of Melchizedek. In the name of the Father, and the Son, and the Holy Spirit. Amen. Well, first of all, thank you all for joining us this afternoon for this session. We at Men of Melchizedek greatly appreciate our priests, our deacons, and our bishops for all the work that you do for Mother Church. We at MOM pray for all victims, our priests, and especially our bishops, who are often charged with having to make very difficult decisions. On behalf of the board of directors of MOM, we're grateful for your concerns on the issues that are detailed in our model policy, which will be covered today, as evident by the dozens of you who have taken the time out of your busy schedule to join us this afternoon. I'm unique to the board in that I am not a lawyer, and I am not a canon lawyer, nor am I a civil lawyer. I was exposed to the need for an organization like Men of Melchizedek through a very personal experience. My daughter met a young man in college, and shortly afterwards, they got married. He was a cradle Catholic and pretty lukewarm in his faith. They started a family and joined a parish, and his faith was reignited, mostly through the enthusiasm and zeal of a young associate pastor at their parish. They quickly had a family, and this young associate pastor baptized their first two daughters and was making great strides in cementing the faith throughout the entire family. And for that, we were very grateful. He was not able to baptize their third daughter as he was abruptly and unceremoniously removed from his position as associate pastor due to accusations that would later be proved to be false. Shockingly, he was removed from his residence, and his diocese even stopped paying his salary. We stayed in close contact with this young priest and helped him financially when we could. His saga went on for 3 years. During that time, his father passed away, and he could not even preside over his own dad's funeral mass. This particular story does have a happy ending, but as you will hear later, so many do not. I know firsthand that this young priest came within an eyelash of giving up completely and leaving the priesthood. What a loss that would have been. Unfortunately, this case is not unique. In this year alone, Men of Melchizedek has assisted hundreds of priests who have suffered through similar circumstances. We at MOM are driven by justice. We want justice for those victims who have truly been wronged. We also seek a just resolution for those priests who have harmed others through their acts and deeds. And of course, we seek justice for those priests who are experiencing the horrors of a false accusation. Without further ado, I would like to introduce to you a man who can best be described as the heart and soul of Men of Melchizedek. More accurately, he's the tip of the spear when it comes to serving troubled and distressed priests and bishops when they feel they have nowhere else to turn. Since 2002, he has facilitated assistance for thousands of Catholic priests accused of sexual abuse. It is with great pleasure I'd like to introduce to you our president, Mr. Joe Maher.
Thank you, Paul. And thank you for all of you who are attending this webinar. I imagine some of you know me and have known my work through the years and our work now at Vademecum. What Paul said is absolutely right. It started in 2002. Started helping one priest at our local parish. My wife, who was raised evangelical, insisted that we do something to help him, and I'm glad that we did. We helped not only to find him a place to live when the Archdiocese refused to support him in any way. We had to find him a legal team. We actually took part in the investigations, which is what we're going to talk about today. And after he went through a highly publicized criminal trial, which lasted about 5 days, he was acquitted of all charges, thanks be to God. Most priests are not that fortunate. The reason why I bring that up is because I think it's important that we know a little bit of the background of what we're going to be talking about today. In August of 2021, a religious order contacted us. I talked to one of their principals there, one of the superiors, and they were struggling with the way that they could address the sexual abuse crises within their own order. And the crisis that took place for them was a couple of priests had been accused of sexual abuse. They wanted very badly to take care of their brothers, but also they wanted to respect the rights of the victims and those who have alleged that they were harmed by one of their brothers. So just kind of as we were talking, one of the superiors, who was a canon lawyer, said to me, well, would you, by any chance, through all of your experience, these 20 years, be able to put together some kind of a policy, like a model policy for us and other orders and other dioceses to follow? That's how this whole thing started. In fact, that's how I started in the beginning and how we've started through the last 20 years and how we've continued to grow and how we've continued to serve the priesthood. It's come from the priests themselves that have asked for help. So that's what we did. We set about, we talked to the board of directors, we agonized over it, and we spent a lot of time putting something together, and we had it reviewed by many within the church and also with plaintiffs' attorneys. And through this whole process, I believe we've come up with a pretty good policy that I would like to see, if possible, the church look at as possibly standardizing throughout the universal church. Right now, the biggest complaint by priests by far is the lack of due process. 20 years ago, when I started helping priests then, the same exact complaints by priests then are the same ones today. And that is the lack of due process, sometimes the gross lack of due process. And in my opinion, my humble opinion, I think it's gotten worse. I think at the beginning, those first 5 to 10 years from the start of the charter in the June of 2002 to about 2010, 2007, there was just an onslaught of priests that were accused and removed from ministry. It's been steady, but with lulls. Over the last 3 or 4 years, it's alarming the number of priests that are being accused. They don't make the media like they used to. They do the local media. But as we say, the pendulum is swung. We've done so much to help victims, and rightly so. Protecting our children should be our first priority. But in doing that, we've sacrificed literally lives of priests and their ministries. And I think we can do better. I mean, Vademecum, we're not here to criticize, the hierarchy for things that they didn't do, but we certainly want to bring out ways that we can do things better. And that is in the treatment of the priests. And I don't think there's a priest on the face of this earth, at least in the United States, that doesn't know that one phone call and they can be accused or removed from ministry. Their biggest concern is their rights and the ability to have some kind of process, a due process that will help them and help protect them. Now, priests have done things wrong. Paul has said that at the beginning. We understand that, but as Christians, we have to also look for the just resolution in those matters. And then we have priests that are flat out falsely accused. They're removed from ministry. Their names are broadcast in the marquee of a sex offenders registration on diocesan websites. I'm not using the term to be flippant or cruel towards the diocese or bishops. I'm using that because that's exactly the term one archbishop used when he said we have our own sex offender registry on our website. Now, many of these accusations are unproven. And as Christians, as a Catholic Church, we're supposed to be setting the standard for not only justice, but mercy, because God's justice is mercy and mercy is God's justice. But we also have to set the standard on how we treat each other as Christians. And we're not doing a very good job. What we've shown the world is that, yes, we are reactionary when it comes to being bombarded by the media and by plaintiffs' attorneys and trying to put a good face on what is something that's really happened very terribly with the abuse of children. But the fact of the matter is, we don't do a very good job of taking care of our priests and showing the world that we can distinguish between what is right and just and having the courage to do right by our priests. We haven't done a good job of that. And we have to, because we're also showing our own, especially with lay people like us, if we can't take care of our priests, and if our priests can't be redeemed, and our priests can't be helped and healed, and if our priests can't return to their rightful place in the community, in the Christian community, what does it say about us lay people? As one priest said from the pulpit not long ago, and pointing at the confessionals, you see those confessionals, they work for you, but not for us. Okay. So here we are. We've decided to put together a policy, model policy for this religious order. And as we're going through it, we have to start from the basics. And that's what we want to address today, the investigation. One of the most alarming things that I've experienced in over 20 years, and now we've experienced in Vademecum these past couple of years, is the lack of investigation. Priests are always saying, when is somebody going to ask me what happened? When do I get to tell my side of the story? How can the bishop just believe what somebody's telling them and never finding out if there is any truth to it or investigating it? And this is really important, because if the bishop truly cares about his priests and cares about the situation, which I believe they do, then they have to investigate to find out what facts are available and then make an informed decision. It's kind of like a doctor who somebody calls him and says, Jerry is sick. I don't know what he's sick from. He just looks like it. I think he's sick. And the doctor, without talking to Jerry, without making an examination, without finding out what kind of issues he's experiencing or what's happened in his life, summarily, like other patients he may have, prescribes something that could adversely affect him, or prescribes nothing and leaves him in his sickness. We can't, the bishop has to know what he's dealing with exactly. And that only comes out from a competent and thorough investigation. And that's not happening at all. And you'll see with the two gentlemen that follow me, Dave and Michael, who are both experienced attorneys and have put a lot of work and time and effort into this, that without investigation, how do we even begin to talk about due process and the rights of priests? We can't. The investigation is the foundation of everything. And if we don't do the investigation, and I'm not sure why bishops don't do the investigation, I have some ideas, and based on my experience, a lot of it has to do with many factors, including legal representation, insurance, media, advocates, victims advocacy groups, not wanting to look like they're not caring or taking the victim seriously. Well, we can take accusations seriously. And we should be taking accusations of sexual abuse by clergy seriously. But we also have to take just as serious the discovery of what could be truth or what may be false or anywhere in between. Some priests may need more help in healing, and others may be completely innocent, and they're thrust into things like Catholic treatment centers for assessments, where they're going to lock them up and give them polygraph examinations. It's going to hurt them. It's going to hurt them emotionally, mentally, psychologically, and spiritually if they're falsely accused. On the other hand, if we treat every single accusation as if it's a gospel truth without any investigation, we're not going to have any priests left. And I know that sounds flippant, but it's true. We're going to end up with a priesthood that is scared to speak from the pulpit, to be around people, and it's starting to happen now. And evangelization goes out the window, which is what we're first called to do. We're supposed to help each other get to heaven. That's the goal right now. That's the goal of our life, right? To spend eternity with Christ. I got a call from a seminary not long ago, a very large seminary. Mr. Maher, can you help us? There's a group of us. We're starting our last year of theology. Well, I know what that means. That's transitional deacon time. Well, their biggest concern was, what happens if we get accused? What happens if somebody accuses us? Is our bishop going to support us? Another seminary from a different seminary said that the rector, when he went to talk to him, told him directly, don't count on the bishop to support you. If you get accused and removed from ministry, call mom. Okay, we're here to help, and absolutely we'll do everything we can do to help. But it doesn't bode well for men and the parents of young men who are discerning and considering even the priesthood. It doesn't. I can tell you, parents I've talked to and have called us on the phone, I don't want my son to go into the priesthood, because anything happens to him, they'll abandon him. And worse, his reputation, his life will be ruined. Those are the stakes. Those are the things that are happening right now in our church that we're trying to address with this. And you know what? As I said before, we've done a great job at really working hard at protecting our children and doing our level best to prevent sexual abuse in the future. And that's what we should be doing, because there should be no more victims. And the horror and terror and the pain that victims have had to endure is not only unfair and unjust, it's embarrassing. And it should never have happened. Not by our religious leaders and not by our ministers. But we haven't done a very good job with addressing it with our priests. We can't just throw priests under the bus. And I'm saying it in these terms because we're witnessing it at Vademecum. And if I could say it, it's in a ferocious level, because whenever there are some dioceses that if a priest is accused, he's done. One bishop told some of his priests at a priest function that if you're stupid enough to put yourself in a position to get accused, don't come looking for me for help. Those are harsh words, especially to your priest sons, who you're supposed to be a father figure to. Who do they turn to in their time of crisis and need? Well, they like to think that they could turn to their bishop. That priest-bishop relationship has been almost severed in many circumstances, but it is certainly strained. So I happen to believe in our church. We at Vademecum love our priests. We love our church. We believe in our priests. We believe in what we can bring to the world and saving the world, and we can do it through our priests. And by the way, for the priests that are out there, don't think for a minute that the devil isn't involved in all of this, because he is. He's trying to tear you apart, rip you to pieces. And that's part of this. Let's stop, take a breath now. It's been 20 years that we've heard the same thing over and over again from priests, and that's the lack of due process. I'm asking you to please take time today and really listen to what Michael and David have to say. There's going to be another webinar in February where we're going to have Joe Rashad, who's a very experienced criminal attorney who actually performed a very complex, competent, and thorough investigation for an order in a diocese on a priest that was accused of sexual abuse. He's going to go through all the steps that were taken. And because of his investigation, good things have happened. But the most important good thing to have was he could give the superiors and the bishops accurate, timely information based on facts, so that they could make the right decision on how best to help this priest, or if this was an entirely false allegation. I want to thank you again for being here. Please pray for us at Vademecum. And I can't leave without saying that, if you ever need to call us, you can talk to us confidentially. Please call us. Thank you, Paul.
Joe, thank you, and thank you for your diligence and your dedication and all that you do for the church and all that you do for our priest. I just noticed that we are getting some questions and answers that are coming up. Do we want to address those at the end, or should we take those as they come? Anybody got a thought on that?
I think we should address them at the end. So
Okay, we'll go ahead and do that. But if you have any questions, keep sending them in. We'll get to as many as we can. Our next speaker is Dr. Michael Mazza. Michael is both a civil attorney and a canon lawyer. He graduated magna cum laude from Pontifical University of the Holy Cross in Rome, where he now teaches as an adjunct professor in the program of church management. He has 20 years experience in US civil law, and he's going to now take us through a presentation on the rights of the accused. Michael.
Thank you, Paul. And thanks, Joe, for sharing those powerful stories. We've got a lot of ground to cover in my allotted 20 minutes, so let's get right to it. Those on this webinar are probably already well aware of this, but I think it's helpful to recap what led to the most recent Vademecum, which is essentially the Latin concept for a handbook. In the so-called Summer of Shame of 2018, the internet was full of stories about the Pennsylvania grand jury report, Theodore McCarrick, Archbishop Vigano, among other things. That next February, a summit was convened at the Vatican on the protection of minors in the church. One of the recommendations made there called for the creation of a practical handbook on the steps to be taken by church authorities at key moments when a case involving an accusation of clerical sexual abuse emerged. The first version of this handbook was released in July of 2020, and the second, slightly revised and updated, was released just this past June, coincident with the effective date of Predicate Evangelium, the Apostolic Constitution on the organization and operation of the Roman Curia. Among many other innovations was the change in the names of the congregations to dicasteries, so we'll have to get used to calling it the DDF rather than the CDF from now on. I put a link to the most current version of the Vademecum on the slide that you should have in front of you, as well as its basic outline. Given today's time frame and format, I'll be able to mention only a few key concepts contained in it, and I'll be focusing especially on how it treats of the rights of the accused. And please note, I'll be referencing only version 2.0. On this next
Michael,
slide,
I don't know. Michael, I just want to say, we don't see your screen, I don't believe, your slides.
Okay, sorry about that. How about that?
Yeah, we see it now. You might want to just make it into a PowerPoint. There you go.
How's that?
Yep, we're
All
good.
right. Apologize for that. All right, so this is the road to the Vademecum. As I said, the developments that led to this handbook, this practical handbook, and that's a link to the Vademecum. There's, again, two versions, one in 2020, one in 2022, and then there's the outline of the handbook itself. This is the list of some recent professional literature on the subject to which you can refer if you want more of a comprehensive picture. And again, just to be clear, given the target audience of this webinar, I'll only be making reference to the 83 code. Now, my remarks today won't be limited merely to the Vademecum's take on the rights of the accused. First of all, the Vademecum is not intended to be some kind of manifesto or Bill of Rights. It's just a practical handbook for handling only certain kinds of gravely serious abuse cases. Secondly, the rights of the accused we're talking about this afternoon are fundamental human rights, granted by God outside of and prior to any right stemming from a person's identity as a Christian. Now, if your eyesight is really keen, you'll notice that this is the Magna Carta. Now, while canon law recognizes these types of rights, it's not granting them, as is clear from the teachings of the Second Vatican Council, among other sources. And while it's certainly a good thing to see the DDF express esteem for these rights, it's not the DDF, the Pope, or the Code that's somehow bestowing them on accused clerics. Needless to say, church authorities can't take away such rights either. These days, a simple truth bears repeating. Catholics don't lose their human rights on the day of their baptism or the day of their ordination, for that matter. Now, that said, I think it's vitally important that we also avoid the risk of viewing rights in isolation. I want to stress at the beginning of my comments here today that real victims of actual clerical sexual abuse have suffered extraordinarily grave harms and have real rights, both with respect to reparation for the terrible damages they've suffered, and to know that the structures facilitating their abuse have been challenged and changed. This was essentially the message of Pope Benedict XVI in his letter to the Irish Church in March of 2010. And if that means, for example, publishing lists of names of perpetrators who've been condemned after a civil or canonical trial, then so be it. If the common good requires it, people who've been proven to be dangerous to the community deserve the bad reputation they've earned for themselves. And as we take a look at rights, whether those are the accusers or the accused, let's not forget the rights of the broader ecclesial community as well. The faithful, after all, have the right to make known to their sacred pastors their needs and desires, as well as their opinions of matters which pertain to the good of the church. They have the right to receive the word of God and the sacraments, and they have the right to legitimately vindicate and defend their rights and not to be punished except according to the norm of law. It follows from all this that they also have a right to see perpetrators brought to justice, as well as the right to object when they see their priests being treated unjustly or summarily thrown under the bus once an accusation is made. And as we all know, or there'd be no need for this webinar, examples abound of sad situations when the rights of accused priests have been violated. Now, with those introductory points made, I'd like to briefly discuss some of the specific rights of an accused person. Given the focus of the webinar, I'll be concentrating on how these rights may or may not apply during the first stages of the process set in motion by an accusation against a priest. Some rights of the accused are specifically mentioned in the 2022 Vademecum. Others are at least implicated. Still others aren't mentioned at all in the Vademecum, although they may be mentioned in other recent norms. And finally, some rights may not even be applicable in an ecclesial context for reasons which we'll discuss. And keep in mind as well that there's some degree of overlap within these broad categories. A quick aside, the Vademecum applies only to those cases brought to the DDF. By analogy, we can apply certain aspects and principles to other cases. Dave Schoenefeld will talk more about this next, but you'll see that the model policy is designed to capture a broad category of allegations, given that the reality in the US today is that review boards are being used to process all kinds of allegations, not just graviora delicta. The right to the exercise of defense. This natural human right is, as I said earlier, recognized in the 83 Code under Canon 221. It's also referenced many times in the Vademecum, always with the sense that the right of an accused to defend himself against allegations of wrongful conduct is inviolate. This right was also specifically reaffirmed by Pope Francis as one of the 21 points of reflection coming out of that February 2019 Vatican Summit. The 14th point is entitled The Right to Defense. We'll see exactly what it says about that shortly. Does the right to defense include the right to an attorney? The law is clear that during a penal process, whether judicial or extrajudicial, the accused has a right to counsel per Canon 1723. During a Canon 1717 preliminary investigation, however, Article 54 of the Vademecum states merely that while a person is under such an investigation, quote, it is not obligatory to name an official advocate for him. If he considers it helpful, however, he can be assisted by a patron of his choice, close quote. I've seen situations in which a diocese or religious order claims that the accused has no right to a canonical advocate, at least when there is yet no official canonical process. As a technical matter, their point is valid. But on the other hand, given that every member of the faithful has a right to vindicate and defend his rights, it seems only appropriate and even necessary that once someone's rights have been put in jeopardy by an accusation, the person accused must have access to sound canonical counsel, lest they lose the war before the first battle even begins. Something to consider. When a priest is first brought in and told of an accusation, how's he treated? Does he walk into a room full of lawyers? Is he told of his rights, especially his right to defense? Now, in the civil world, at least after the US Supreme Court's 1966 decision in Miranda, if an accused isn't told of his rights, any subsequent conviction might be thrown out. Is that a technicality? Or is that a sign that even the state acknowledges that human beings who are accused of a crime have a fundamental right to a competent defense? The right to being presumed innocent until proven guilty. As mentioned above, after the December 2021 revision of Book 6, Canon 1321 specifically provides for the presumption of innocence. Any person is considered innocent until the contrary is proved. The 14th point of reflection I mentioned a few minutes ago affirms that it's necessary to safeguard the principle of natural and canon law of the presumption of innocence until the accused is proven guilty. This right is stated, albeit indirectly, in Article 45 of the Vademecum, in the context of a general provision regarding public pronouncements. It says, especially in cases where public statements must be made, great caution should be exercised in providing information about the facts. Statements should be brief and concise, avoiding clamorous announcements, refraining completely from any premature judgment about the guilt or innocence of the person accused, since this is to be established only by an eventual penal process aimed at verifying the basis of the accusation and respecting any desire for privacy expressed by the alleged victims. Beyond these provisions, it's helpful to review the holding of a 2017 case from the Apostolic Signatura, Quorum Versaldi. The sentence effectively chided a bishop for not coming to the defense of one of his priests who'd been unjustly accused, noting generally that public opinion can be easily manipulated and that for that reason alone cannot constitute sufficient proof of accusations. The decision added that in the particular case before the tribunal, the priest had actually been exonerated, both civilly and canonically, of the crimes of which he had been accused. All the more reason, the Signatura states, for the bishop to have observed his duty to protect the rights of one of his priests under Canon 384. The decision goes on to speak of the duty of a prelate to form properly the consciences of the faithful with respect to a falsely accused priest, especially if the tide of unfair public opinion is swelling against him. This fundamental right to the presumption of innocence is intimately connected to the right of reputation, which is referenced repeatedly in the Vademecum. Article 44 in particular states, the one who carries out the preliminary investigation must therefore be particularly careful to take every possible precaution to this end, since the right to a good name is one of the rights of the faithful upheld by canons 220 in the Latin Code and 23 of the Eastern Code. It should be noted, however, that those canons protect that right from illegitimate violations. Hence, should the common good be endangered, the release of information about the existence of an accusation does not necessarily constitute a violation of one's good name. On an interesting side note, the language in Article 54 of the new Vademecum makes a subtle change in terminology. At least in the English version, instead of calling someone an accused, the phrase "the person under investigation" is used. A small but significant distinction, in my opinion. Once again, we see this right being specifically referenced at the 2019 Vatican Summit in the same point of reflection cited earlier. It is necessary to prevent the lists of the accused being published, even by the diocese, before the preliminary investigation and the definitive condemnation. Now, this issue of publishing lists of credibly accused merits a webinar of its own, so we can't get into it in any depth here and now. But let me simply pose a few questions. When press releases are posted on diocesan websites and handed to the media, are there statements about the right to the presumption of innocence and the right to a good name? Are such statements positioned in the announcements so that people take note of them, or are they in small font and thus go unnoticed? Are reinstatements of clerics publicized in the same way as their removals? Keeping in mind that canonical doctrine and erodal jurisprudence have long acknowledged that defamation can happen not only by word, but also by deed. What to make of interminable and unexplained absences from all public ministry? The right against self-incrimination is referenced specifically in the Code, Canon 1728, and in the Vademecum, Article 54 and Article 110. The accused is not bound to confess or admit to the delict, neither can he be required to take an oath to tell the truth. Now, this can come into play when a priest is interviewed by the diocesan investigator. Is he advised of his right to remain silent ahead of time? Is he asked questions, even indirectly, that violate his right against self-incrimination or his right to privacy? Many priests can't wait to tell their side of the story, but are painfully unaware that the diocesan investigator or the members of the review board may have very little, if any, incentive to either believe him or to make a recommendation that might restore him to public ministry. Many priests simply promptly sign the HIPAA forms at the door of their therapist or treatment center, unaware that they are under no obligation whatsoever to hand over those confidential medical records. The right to privacy, we should keep in mind, is specifically referenced in the 83 Code in the same canon as the right to a good name, that is, Canon 220. Now, the right to a speedy trial, Article 66 of the Vademecum states this: it's recommended, for the sake of equity and a reasonable exercise of justice, that the duration of the preliminary investigation correspond to the purpose of the investigation, which is to assess the plausibility of the notitia, the notice of the crime, and hence the existence of the fumus delicti, or the evidence of the crime, signs of the crime. An unjustified delay in the preliminary investigation may constitute an act of negligence on the part of ecclesiastical authority. Well, the phrase justice delayed is justice denied captures a basic principle of fundamental justice dating it back at least to the Magna Carta in 1215. Within the context of a preliminary investigation, delays can further the reputational harms of an accused priest, as well as the damage to his physical and or mental health. It's interesting to note that with respect to bishops, the motu proprio Vos Estis Lux Mundi contains specific timelines for action: 30 days upon receipt of an initial report and 90 days for the conclusion of the investigation. Now, having said all this, I want to emphasize that ecclesiastical authorities must never interfere with a legitimate criminal prosecution brought by secular authorities, particularly one in which the investigative tools of a modern police force are much more sophisticated than anything available to a bishop. Nevertheless, we must never forget that the ends of civil law and canon law are fundamentally different. While state authorities seek to keep the peace and foster the common good in a general sense, church authorities are bound by their oath of office to abide by the requirements of canon law. So we should be very careful about just handing over to the state the duty of investigating every allegation against a priest. The secular state may be ill-equipped to handle such a task, and there are certain things that a bishop simply can't delegate. Now, the right to know the charges and the right to confront accusers. One thing Americans must remember is that there are important distinctions between the adversarial system of justice we have in the US, think of courtroom dramas and famous movies, and the inquisitorial system we have under canon law, which is more common in European systems as well. For example, the judge plays the role of an impartial referee in the former. In the latter, he's more directly involved in the search for truth. Moreover, keep in mind that the supreme law of the church is the salus animarum, salvation of souls. Saving souls is clearly not on the agenda of an American state court, whether it's a civil trial or a criminal one. It ought to be on the mind, however, of every bishop. He's duty bound to consider how to do the right thing in this particular difficult situation, given all the goods at stake, which are not exclusively temporal. In that vein, then, let's take a quick look before my time is up here at such concepts as the right to know the charges.
Michael, please unmute yourself. Mike, unmute yourself.
Don't know how that happened, but that's all right. All right. Are we back on?
Yep, go ahead, Michael.
Okay. All right.
Turn it back to a PowerPoint. There you go.
All right. So the supreme law of the church is the salvation of souls, the salus animarum. I was talking about Articles 52 through 54 in the Vademecum, which addresses the particularly sensitive issue of whether a bishop should inform the accused of the charges against him. Various goods are at stake. Everyone involved has the right to reputation. The accuser and his or her family, the accused and his family, witnesses, everyone. There might be a risk of scandal, witness tampering, or spoliation of evidence. Bishops may also decide not to bother the psyche of a priest whom the bishop suspects is being accused merely out of jealousy or spite or retribution. So in light of all these things, there's no right for the accused to be informed of the charges, much less to confront his accusers or witnesses at this early stage of the process. And with that, I'll turn it back over to Paul, who will introduce our next presenter, Dave Schoenfeld.
Hang on. Okay, I think we're back on. First of all, Michael, thank you so much for all your hard work on the model policy and for a great presentation this afternoon. Our last speaker is Dave Schoenfeld. Dave is one of our board members and co-author of the model policy. Dave is an attorney with the Alvarez firm in Calabasas, California, where he specializes in insurance coverage cases against insurance companies. He's a graduate of Thomas Aquinas College and Willamette College of Law, and he has served in the United States Department of Justice under the Reagan administration, where he was the co-author of a model drug testing policy covering some 2 million federal employees. He is among the 5% of attorneys in Southern California recognized as a super lawyer, and we are pleased to have him address for us the major provisions of our model policy. Okay, Dave?
Great. Thank you very much, Paul, and thank all of you for joining us for this. Got a lot of information to go through. We are sensitive to your time and trying to figure out how to budget and highlight the main points here. But you've just been hearing the general backdrop regarding this whole policy. Most bishops or societies use review boards, and the purpose is to assist in decision making. And what we found, though, is that procedures vary widely, and so do the application of procedures as well. And the biggest question here that everybody has is whether fundamental rights of due process have been recognized. Sometimes they are, but sometimes they are not. And so our goal here was to develop a model policy that would do that. It would assist bishops and the review board in promoting justice. It would protect an accused's fundamental rights of due process as well. So let's talk about some of these underlying principles then that undergird this. First is that civil law aims to protect the civil common good, but canon law is different. It aims to protect the ecclesial common good and salvation of souls. And the purpose, of course, is to do three things: restore justice, repair scandal, and to reform an offender. The second principle: no punishment is appropriate. No punishment is appropriate under canonical penal law unless two things happen. There's an external provable violation of law that has occurred, and second, that it's gravely imputable to the actor. Okay, so that's the only conditions under which penal law can be opposed under canon law. 3, an accused is presumed innocent. Very fundamental principle. 4, every human being has a natural right to privacy. 5, every human being has a right to a good name. 6, no one can be required to take an oath. 7, a preliminary investigation is not part of the formal penal process, but in our experience, for all practical purposes, it really is. And it tends to function like a grand jury does. It determines whether formal charges should be filed or not. And in many cases, the investigation is over once the preliminary investigation is over, which is not what it's supposed to be. And the final point here is this, and this is important. The review board is to assist the ordinary. It is not to supplant the decision of the ordinary. The ordinary always has ultimate discretionary authority about what to do. So this model policy is composed with 4 parts in mind. First is a purpose, second, underlying principles, third, certain definitions, and then fourth, the initial process, this preliminary process that we've been talking about. So section 1, purpose. Why do we have this model policy again? Well, we codify the principles that we've just been through, and we do it in each of the various sections in some detail. The principles are to care for persons, to restore the pastoral relationship, to pursue justice, and to receive complaints, and to assure complainants that they will be treated fairly, seriously, and compassionately. It's also, though, to codify principles with respect to the rights of the accused that we've been discussing. We have to treat the cleric fairly, seriously, compassionately. And we recognize that there are profound challenges at stake: emotional, psychological, reputational, and not just to the clergy, but to family, friends, and the local community as well. We want to confirm the presumption of innocence. It's a bedrock principle of jurisprudence. We want to confirm the right to a good name. This is a historic right under canon law, and anybody who can talk about it in great deal is my good colleague Michael Mazza, who wrote his doctoral dissertation on the history of the canon of the right to a good name. But this side of the Garden of Eden, we have conflicts of interest. Conflicts of interest aren't bad; they exist. I'm an attorney. That's my role. My vocation is to engage in conflicts of interest. So we need to admit them. It doesn't do us any good to hide them. And we have conflicts of interest here. On the one hand, we have a need on behalf of the victim to investigate, evaluate, and address the victim's claims. Those are fair. On the other hand, we also have a need to protect, to defend, and absolve anyone who's been wrongly accused. All right, so if we're at least clear that a conflict exists, then we can talk about how we can address those conflicts of interest. And we have to do it against explosive historical factors that exist right now in our day and age. The incidence of past sexual abuse, suppression of reports, the distrust of complaints, the reluctance to apply canon law, insensitivity to victims, adverse publicity, hostile media, hostile advocacy groups, and dare we say, protection of privileged ecclesiastics. This happens too, and people are aware of that. And these are all factors and problems that go into the mix here in determining what procedures would be fair or not. Now, lastly, this. I mean, we think about this. We have true conflicts. We have very, very serious issues at stake. So we want to make sure that prayer is involved, is mandated. This is the core of the church's mission, to save souls and protect the priesthood. So why should we not pray for this? And then in all fairness, we have to be crystal clear about this. It's not just flesh and blood that they're dealing with, as Ephesians tells us, it's spiritual hosts of wickedness in the heavenly places. So we've got a two-front war that we're dealing with. We need to engage on all aspects of that war, and prayer is one of them. And so it's It's not just a nice reminder. It's an essential component of the whole process that prayer be involved in this. So let's talk then about section 2 in the model policy, which covers the underlying principles here. First, the importance of chastity. The policy exists for the purpose of addressing sexual claims. It presumes a breach of chastity. That's fundamental to the core mission of the church, and we need to recognize that. Second is the spiritual mandate from our Lord gives us in Matthew chapter 18. If you have a problem and you can't resolve it with one or two people, then you tell it to the church. Well, this process does that. It tells the problem to the church. Now, we also recognize the ecclesial authorities that are involved here. There are a bunch of them. You've probably heard of most of these. Of course, the Dallas Charter, they got passed in 2002. They're the essential norms that occurred thereafter. There's a motu proprio on dealing with investigations. And as Michael discussed, we have the Vademecum as well. So we want to recognize all of these as underlying principles to the model policy. I like this whole concept of Vademecum because, as Michael explained, there are really, really important rights that are declared there that seem to be glossed over. But never forget what the Latin is for it. Okay, harken back to your Latin. Vademecum means go with me. And what this is, I think this is really cool. It's a handbook or guide that's kept constantly at hand for consultation. So, if you're involved in a hearing of some kind, you should ask all the people involved, do you have a copy of the Vademecum with you? Because it's supposed to be constantly at hand for consultation and, watch the blank stares come up. But that's why we have this, and everyone should know about it. We've been through the principles, confidentiality, participants' right to a good name, notice to the accused, somewhat discretionary, but we'll talk about that. The right to an advocate, somewhat discretionary, but we could talk about that as well. And prohibition on oaths and a right to a prompt hearing. Now, in 2.4, we talk about the duties and commitments that the church has in all of these investigations. They have to treat all allegations seriously. They have to respect the rights of all involved. They extend the ministry to victims. They have to hold clergy adjudicated guilty as responsible, and they have to exonerate clergy that are adjudicated as innocent. We have to educate clergy and people about the problem. We have to educate clergy and people about false charges. We have to perfect screening procedures for candidates, obviously, and also as a given, cooperate with law enforcement. Now, the policy distinguishes between immoral conduct and criminal conduct. The church, of course, condemns both, all sexual misconduct. But some of that conduct amounts to an ecclesiastical crime, sexual misconduct. And then some amounts to actual civil or criminal crimes, sexual abuse. Well, the policy here is going to investigate both kinds because they both come under the ambit of all the principles that we've been talked about, and the principle of which is chastity. Now, section 3, of course, is typical, has your average definitions in there, but there's one that we should talk about because it kind of goes to the core of what the whole policy is about. And that's the definition of credible or credibility, a finding of credible regarding a report or a complaint. That is the whole goal of the process here, is to have a committee or a bishop approve or disapprove a committee's finding that certain allegations are, quote, credible. If the complaint's credible, then the complaint moves forward, supposedly. As I said, as a practical matter, sometime game over. But if it's not credible, then the matter is dropped. And so that's why credible is a very serious issue. The way it's defined, commonly defined in a lot of policies, Vademecum and others, is that the committee has followed procedures and found that, quote, a reasonably cautious person would believe that the allegations probably occurred and that the accused is the one who performed it, such that a subsequent penal process is warranted. All right, a lot of loaded terms there, right? Reasonably cautious person, what's that? Good question. Would believe, what's that? Allegations probably occurred, what's that? Well, those are all, legal terms, and this is what the law has fun fleshing out. Some of the policies are a mess because not only do they throw in, a definition of credibility, but they also throw in a definition of probable or probable cause. How do you figure that out? When that you have a reasonably cautious person believe that allegations are probable? I mean, you can get to a legal vortex here real quickly if you don't do that. So we've kept this very simple and cautious to the three fundamental elements at stake that are here. Just so you can understand this in the context of legal standards in general, the lowest legal standard that you'll ever find in the law is something called some evidence, or a scintilla evidence, that is used in favor of something. Sometimes courts will raise the bar a little higher and call it reasonable indications. Some say reasonable suspicion, such as you can't have a drug test of somebody without reasonable suspicion of drug use, or that it's reasonable to believe. Okay, see, we're getting a little bit higher up on the thermometer with this. There's probable cause. That's where that comes in. Search warrants shall be issued on probable cause. So fairly low, but still got to be something. And then comes credible. Credible's right there with the definition that we gave it. Above that, it's very close to and somewhere in the neighborhood of what we call preponderance of the evidence, which is what civil trials are decided on. Basically, 51% of the vote. You got a tipping of it's preponderance, bingo, you have preponderance of the evidence. After that, you have a higher standard, clear and convincing. That's what you prove in fraud cases, for example. And then in criminal cases, we have beyond a reasonable doubt. Okay, so with that definition in mind, let's then talk about how the process goes and what the procedure is here. Well, we start with the complaint or a report. It goes to an ombudsman, and he or she is person appointed to receive these complaints. They collect the details, date and time of the complaint, the identity of the cleric. They basically get the nuts and bolts of what's being claimed. Now, how about false or anonymous complaints? Should they look into that? Well, they're potentially false and frivolous claims, and the bishop has to decide whether they're false or frivolous. How about anonymous complaints? Nope, we're not going to process them. Look, law enforcement won't generally process anonymous complaints either, so why should the church? Why yank somebody's collar, pull them off the podium just because an anonymous complaint has come in? It's not fair, and civil law doesn't generally, and criminal law typically doesn't regard it as fair either. Now, having said that, we understand, given the structure of the church and things that exist within it, maybe on the basis of an anonymous complaint and the kind of details that are raised, maybe an ombudsman would have cause to check in further about the allegations. Well, we don't want to put anything that would stop him from do that, but as the Vademecum says, he should do so, but with the greatest of care. Okay, so anonymous generally not investigated except in the greatest with the greatest of care. Now, sexual abuse is something pretty specific. It's criminal. It's an external offense that involves three things: minors, vulnerable persons, and child pornography. And so the definition explains that. Those are things that the civil law is going to get involved in. And there will be mandatory reporting. You got to go to the police. You got to tell the bishop. You got to tell the cleric, and you got to tell the insurance carrier too. Some people have a heartburn over that. I don't, even though I represent policyholders against insurance companies. When in doubt, give notice out. You got to tell the carrier. Now, sexual misconduct is different, as we saw. It's an external offense, alone or with others, and it even includes consensual misconduct between adults. It does not necessarily rise to the level of a canonical delict or a civil crime. Is there mandatory reporting? Yes. Not to law enforcement, though, just to the bishop, to the cleric, and again, the insurance carrier. So what should be done with notice to the cleric? Well, we think Christian Charity says you got to meet in person or by phone, but sending a text or an email, that just doesn't cut it. You wouldn't want it done to you, so don't do it to others. Be a man about it. Give it in person and by phone rather than through some inhuman context. Notice of rights. Now, again, as Michael explained, there are a lot of fundamental rights here that most priests just don't know about. They don't know that they have the right to remain silent, or to an attorney, or to a canonical advocate. They don't know that they don't have to sign any document, or take any oath, or undergo polygraph testing, or submit to psychological evaluation. They just think, well, I'm a company man, so I got to do these things. The bishop wants to, send me to SMU to get a psychological investigation. I guess I got to do it. No, you don't. And you're not doing anything wrong by saying that you don't, because these are church laws that back you up. Now, why do we even give notice to the cleric? Well, I alluded to that. It's a fundamental principle of charity. But, just apart from that, these allegations are deeply unsettling. And the dignity of a person requires some kind of personal delivery when you've got a presumption of innocence on the part of the accused and rights that are well recognized under civil law. If the civil law is going to recognize these notice requirements, why shouldn't the church, it seems to us? We think that you should give a copy of these rules orally and in writing to the cleric who's accused. Give him a copy of the policy. There's no harm in that. So after the notice is given, the ombudsman must then advise the cleric that he's not the bishop's delegee to receive complaints. He is the bishop's delegee to receive complaints, but he does not represent the cleric or the complainant, and he's made no credibility finding. So, let good fences make good neighbors. An ombudsman can make, a good neighbor by just clarifying what his limited role here, and that he's not your buddy who's going to help you out. He's just has a role, and this is his role, and you need to know what his role is. Now, if the matter concerns sexual abuse, which we've talked about as a criminal issue, then what will happen is a committee will meet to determine credibility. An investigator will be involved. The cleric will have a chance to appear and contest it through an attorney or his representative. The bishop will have sole authority to make the finding. That's clear. Has to be that way. You can't have committees overruling bishops. All this is to help the bishop decide. And of course, the bishop has to cooperate with law enforcement. That's a given too. Now, if the matter concerns sexual misconduct, same as above, except as we said, law enforcement is not going to be involved. The church authorities may be involved, but that's a separate matter. And of course, given the way the right to silence works, whatever the cleric says or does not say can and use be willed against him. But those are all factors to be worked out and expressly acknowledged as part of the process. The investigator may wish to interview the cleric, but it should be done at a mutually agreed time and location. You can't just show up on your doorstep and say, hey, I got a few questions for you. No, that's not fair. We don't do that in civil law. We shouldn't do it in the church either. The cleric should always be able to have his representative with him. He can bring an attorney. He can bring his, father or son or whatever that he wants to best appear on his behalf. That's part of the fundamental rights that he has to be able to defend himself. And as we saw, he can decline the interview. Very politely say, thank you very much. I really appreciate your questions, but we'll talk about those later. Thank you. And leave it at that. He has a right to do that. Now, there are some exceptions to the notice requirement that we just have to recognize as a matter of practicality. For obvious reasons, we can't just put in a categorical rule that says all clerics have to be notified of all charges at all times. Well, no. Look, if the guy's really gone crazy and you fear that he's going to go out and put an axe through the head of the complainant, no, you don't do that. Or if he's going to go jump off a bridge and he's mentally unstable, no, you don't do that. Or he's in a convalescent home and can't understand and he's got days left to live. No. So we have to recognize some kind of exception to the notice requirements here. Lacks capacity, has a risky medical condition. Obviously, in those cases, common sense will dictate. Now, how about this? The notice of temporary suspension. Very thorny issue. You have allegations made. You have to sometimes act immediately, depending on what happened. All of this, of course, is subject to the bishop's discretion. But the reasons should be detailed in writing, unless there's, again, common sense dictates otherwise. For sexual abuse, obviously, if you have an immediate risk of harm to the common good, then that makes sense. This is a factor to consider. But how about sexual misconduct when there's no crime involved? Well, it seems to us, consistent with the canon laws we've talked about, that restrictions are not warranted for this because, again, clerics presumed innocent, and you can only impose restrictions after there's been a finding that misconduct has occurred. But just because somebody pops up with credible allegations doesn't mean that, you should say, I'm sorry, but your faculties are, suspended temporarily. Again, these, the rights during the temporary suspension are subject to bishop discretion, but we think too, and we think that, the Vademecum and other canon law provisions require that the provision of the same or comparable living arrangements should be provided, exercise of sacramental faculties, support for medical, mental, emotional care if needed, and of course, confidentiality. No release of the name. No release of the name. When's the last time you've seen General Motors release a list of, those who've been, credibly accused of sexual harassment? They don't do that. And the reasons for that, because they get sued for that. The problem is nobody gets to sue the church here because it's, First Amendment prohibits these suits. But if it's not done in civil society, why should we be doing it here? It doesn't make sense. Finally, it's referred to the committee. After giving notice, the ombudsman refers to the committee. It advises the cleric of all of the above rights, the receipt of the complaint, cleric's right to all information that the investigator presents, a reasonable time to prepare for the hearing, a right to be heard at the hearing, and a right to a speedy hearing, which is, canon law says 30 days of the complaint. So if the cleric wants a speedy hearing, he should get it. If he doesn't, because he's got other reasons, then that's fine too. But no one should be left in limbo because negligence will occur, as the canon says. The Vademecum, right? It says in note 66 says an unjustified delay in the preliminary investigation may constitute an act of negligence. That's strong language. That's strong language. You don't see that kind of thing pop up much, and it's popping up here. So we ought to take it seriously. The committee then proceeds as advised. They find whether the allegations are credible or not credible, and then they advise the bishop immediately. Should or can the cleric have contact with the bishop? Well, we think so. I mean, that's what part of the pastoral relationship exists. So if the cleric really wants to meet with the bishop and talk about it, then he should be able to do so. Obviously, the way civil law works, privileges are not going to apply. And so what you say could be used against you, but there's no reason to just prohibit such contact at all. Anyhow, I realize we're kind of at the end of our limit, and we've got to get some questions and answers in here as well, particularly from my colleagues. But if you have any questions anytime about any of these matters, reach out to any of us. Reach out to me or Joe or whatever, and we'll be happy to give our 2 cents for what can be done. Paul, turn it back to you. Thank you very much.
Thank you, Dave. Thanks for a outstanding presentation and for all the hard work that you did on the model policy. I know we're running a little late, but we do have some questions. And what I'd like to do is, first of all, encourage all the panel participants to unmute and put your cameras back on. And anybody who feels like tackling these, we're going to go ahead and I'll read them off and just jump in. Actually, I can read a little better when I made it this small here. Okay, so when it comes to accusations, obviously some are credible and some should be dealt with accordingly, but others are falsely accused. What angers me, though, is even when a priest is cleared and is exonerated, their bishops still treat them like garbage, still don't give them assignments, etc. Can you comment on that? If a priest is cleared and a bishop knows that, why do so many of the bishops refuse to allow them back into ministry? I'm going to just see who wants to grab that one.
I can make the first comment, and then you guys can jump in. I think a lot of it has to do with fear. I think that the bishops, and I've heard this said before, that once you're accused, you're a marked man. And I think the bishops fear the backlash they could have for reinstating a priest that's been accused and what it looks like publicly, and not supporting a victim. I think that has a lot to do with it. Dave could probably comment on insurance liability. We heard a lot about that once a priest is accused, he becomes a liability. And we've had a couple of cases where priests have told us that at least Catholic Mutual refuses to cover a priest who's been accused or has had an issue, not proven, but accused. And I think there's other factors as well. I think there's large benefactors. large contributors that, the bishop is trying to, respect their opinions, but I've heard it said by some that are very wealthy and have influence over the bishop that they don't think that these priests that have been accused should be put back in the ministry. It stinks. But I'm sure there's other reasons these guys could comment on.
Any other comments on that? Okay. All right, we'll move on to another question. One of the biggest challenges I see is that bishops are policing other bishops. Bishops aren't held to the same standards. So there is a gross injustice in the way an accused priest is handled by comparison, particularly in efforts to protect the reputation of someone who has been accused, but the accusation has not been proven. Furthermore, only the church can hold itself responsible to follow its own law and policy. I have found that every bishop does what he wants to do, and it is an uphill battle, to put it mildly, with financial, emotional, and spiritual barriers, preventing a priest from challenging it. And bishops often do not follow even the letter of their own laws, diocesan, Dallas Charter, and canon law. Rome disarates, sadly, overwhelmingly favor the bishop over the priest. Is there truly any hope to change that? How can we mobilize to affect that change?
Hey, Paul, could you turn my video on?
Turn your what on?
Turn the video on. I can handle that. I can handle that question if you want.
Yeah, hang on a second here. Here we go.
Sure.
I think I'm doing it, hopefully.
There we go. Okay,
There you
great.
go.
No, that's a great question, and frankly, in my practice, I get that a lot. I have to say that I know it seems like Rome is. It may seem at sometimes that Rome is just a rubber stamp for the bishops, but I have to say, if you really read the Vademecum closely, and if you see the people who work there in Rome at the various dicasteries. I have been very impressed with the people that I've met over there who work every day, and I think we can take some hope in that. And I know that's not it may appear to be a pie in the sky view, but I think it bears out, and we can never give up. And frankly, this model policy is an attempt for us to do this better, as was said at the beginning.
I'll make one comment. So there's a bishop that was accused a couple of years ago, and he wasn't removed from ministry, and the archbishop of the province was going to handle the investigation. And then there was another accusation against him, and finally there was a third accusation against him. And so somebody in the diocese who related this to me, a layperson, called the bishop's office. And their question directly to the bishop, it ended up being the vicar general, is why wasn't the bishop removed immediately and his faculties suspended? And why didn't he leave his house and have to live with his parents or something? And why wasn't his name broadcasted more in the media? And the vicar said, the reason why is that we don't have the same protocols for bishops as we do for priests.
All right. We have anything else, Joe?
Nope, that's it.
All right. We're going to move on. We have another question here. Believe all victims is one of the biggest problems we face nowadays. Yet this slogan that governs most diocesan independent review boards, I believe these boards are among the reasons why so many bishops disregard the rights of the accused. A lot of them don't care about due process, and many bishops do not question their conclusions. All bishops do is believe them, since they are often former FBI agents, renowned judges, highly honored psychologists, etc. I trust police departments more than I trust these boards. They are too biased, and it seems sometimes they really hate priests. Who wants to tackle that one? It's actually more of a comment than a question, but anybody, any comments on that?
Dave, I think you should talk about what we talked about, the review boards being more like a grand jury.
That is more of a comment than a question that we can all assent to. And all we can do for now is create a standard that we can measure the conduct against. And that is why we have this model policy. I mean, you think about it, it's kind of strange that Dallas Charter came out in 2002, and here we are 20 years later. For the first time, we, a bunch of lay people, we don't work for the church. There are a lot of people who do, and I wish some of them would have had the gumption to put together a model policy, but it took us to do that we think codifies all the proper canon laws that exist like this. If looking forward to the future, if you ask me what my goal, my wish list is fine. All the dioceses in the United States adopt some form of this kind of model policy that has this in place. That then becomes the standard, the gold standard by which others are measured. And when they fall from that and they don't do what they're supposed to do, like you just said, and like you said in the question, then it's easy to hold that up to the light and say, hey, yeah, you were supposed to do this and you didn't do this. That makes it an easy case. So the idea is to put in something, crystal clear by which conduct can be measured, and hopefully it'll change in the future.
Very good.
Thank you, David. One last question we have here is, does the priest have any recourse if the bishop does not follow the directives of the Vademecum?
Yes. Is the short answer. The longer answer is that when bishops don't follow the law, there is a procedure stated in canon law, so that his boss, the bishop's boss, who is the Pope, you can appeal to him. And of course, the Pope doesn't handle all this stuff personally. He has these dicasteries that help him. So depending on the nature of the problem, the request, the appeal, the recourse goes up to one of the dicasteries. If it is specifically a matter of the Vademecum, this would go to the dicastery for the doctrine of the faith itself. And so that matter should be brought to the attention of the DDF.
And this goes to the bigger question that priests ask constantly, and that is, how is it that bishops can just disregard canon law? And we get that all the time, constantly. Just 2 days ago, same thing. Yeah.
Okay. And lastly, we had one more comment. This came from our original questioner, the first questioner. Just a comment, one of the biggest, I don't know what this, it must be a typo here. One of the biggest mistakes, I think, was that the charter, I know the intent of it, but it's a mess and needs to be revised. The pendulum has swung too far the other way. Again, not a question, but more of a comment. So I don't know if anybody wants to comment on that before we adjourn. We have some, Michael, we had some other questions, and David, should we cover those questions as well?
Yeah, well, actually, you have some more questions that are coming in.
We do. I see those right now. Thank you. I'm going to bone up on my webinar skills here. All right. This is one. Let's see, what steps can be done to educate the laity that many of these claims are false? This is particularly serious in New Jersey, where anyone can bring a civil suit against a cleric up his or her up to his age of 55. In other words, for all practical purposes, here in New Jersey, we have no viable statute of limitations. Who wants to grab that one?
Yeah, that's a profound problem. And I think, frankly, one of the ways that we educate the laity is through talking about this model policy and trying to get the word out to people, because there is a duty on the part of the bishops to educate the lay faithful, even as that case that I cited discussed. You know, there's a duty to educate, and you know, we're facing serious obstacles these days, and that's a very good point to talk about these windows that have opened up in various states, allowing for a greater litigation against and let's be serious, not just individual priests, it's against the church, that will affect our ability to save souls. So it's an ongoing battle, and that's one of the issues that we face, it's for sure.
Well, and one of the positive things that have been coming out in the just in the last year, maybe year and a half, is that we do have a couple of bishops, maybe 3 or 4 in the United States, where priests have been accused and removed from ministry. And after an investigation and a review board finding, the bishops have stated publicly that the priests, that they did not find anything that rises to a grave delict, and that the priest is put back into ministry again, or that they did not find, that the accusation was credible. That's huge, because not only does it go a long way to restore the priest's good name and his reputation, but I think it also signals to the lay faithful that, you can't believe, not every single one of these accusations is going to be true, or, there may be mitigating circumstances, or there may be something in between, and as Michael and David talked during the model policy, there's a big difference. It may not seem like it, but there's a big difference between sexual abuse and sexual misconduct. And I think that, like they were saying with the model policy, that can help the bishops to better ferret out these things and get priests back to where they're supposed to be once the accusation's made. The biggest thing that priests fear, as I said earlier, the biggest thing that priests fear is the lack of due process. They know that they can be accused. Every priest knows that they can be accused. They know their butt's on the line. They really do, that there's a target on their back, that the devil's after them, and he's going to use everything against the priest to stop his ministry. And they know that. They're aware of that. But their fear is that there's going to be no due process. I can't be protected. The church isn't going to protect me. My bishop certainly isn't going to protect me. He's going to throw me under the bus. And I think the other side of that is priests that are falsely accused, I always say to them, you need to scream it from the rooftops. You really do. You need to scream it from the rooftops. You can't be afraid to not say that, look, there's been a false allegation made against me, but under the advice of legal counsel, I can't talk about it at this time. People need to know that there really are false allegations being made against priests. It's important for the rights, of everyone involved. And like Dave says in his presentation, it's not just the priests, it's the family, it's the friends, it's the community, it's the world. It's our ability to evangelize, to the masses.
Yeah. We have another very good question here that came in that says, dioceses often have priests who have been credibly accused, but have never had a civil or canonical adjudication. They're removed from ministry, but live in limbo for the rest of their lives. The lack of civil action often comes from statutes of limitations. Is a bishop required to bring a canonical case in these instances?
It's a thorny question, very fact specific, but the general rule is if a priest is removed from ministry and is accused, there has to be action on the accusation to protect his good name, for the resolution of the question, for the good of the people, everything. And so, yes, is the short answer. There is a potential problem, because the period of prescription in church law is different than the statute of limitation for under the state. And under certain circumstances, the bishop may request a derogation from prescription, which means permission to, reach back beyond what the church law provides for the statute of limitation on ecclesial crimes. And that's all covered in the Vademecum. Well, that's not all covered, but it is mentioned and dealt with in some degree in the Vademecum. So it's a very technical issue, but ultimately the point is, yes, a priest should not live in limbo, and there are ways to kind of jumpstart the process so that he does not live in limbo for the rest of his life and that he can clear his name.
Justice delayed is justice denied, right? So,
Yep.
all right. Actually, just as a little time check, I know we're way over time. We still though have a couple dozen people still on the line, and we got a couple more questions. So if you have to drop off, we certainly understand. Thank you for all your time this afternoon and for your interest and your support of the model policy and your support of Metamelchizedek. But we have a couple more questions. You feel free. We'll cover them all. And you can stay on if you'd like. Here's one. This one just in. On the subject of timing, what is a bishop supposed to do if an accuser files a civil complaint against a priest? Is your model policy suggesting that we ignore the requirements of the civil law? It's sad that a priest may be out of commission for a while, but I just don't see how we can rush him back into ministry, especially given the risk of scandal.
Mhm.
Who'd like to tackle that?
I can take a crack at that.
Okay.
As
Dr.
I
Monk?
mentioned, canonical investigation is different from and independent of any civil investigation. The Vademecum says specifically that the preliminary canonical investigation must be carried out independently of any corresponding investigation by the civil authorities. Where that's not possible, for example, because the civil law prohibits it, or bishops are invited to consult with the DDF. And the Vademecum also talks about the different criteria used in the civil world, like periods of prescription, elements of the crime, the standards of proof, etc., which can vary widely from those of canon law. Now, let's keep in mind, as we talked about, the DDF only talks about graviora delicta. The Vademecum only deals with graviora delicta. So while special care must be certainly taken with accusations involving that type of misconduct, we must be extremely careful before calling the cops every time that there's any allegation of any kind of misconduct involving any cleric, or even just indiscriminately pausing our own canonical investigation just because there's something else going on civilly or criminally. So if you do that, you could wait 2, 3, 4, 5 years before you handle a priest case, which is just unconscionable. And keep in mind, secular companies do this every day. They make these kinds of determinations every day. Not every type of employee misconduct triggers the involvement of the police, but the reputation of the company is at risk. If the company simply goes limp in the face of every potential piece of litigation or criminal complaint, beyond the risks to the personal well-being and the reputation of the poor employee who has been accused. Now, in the past, some in ecclesial leadership erred, obviously, to one extreme by not involving the civil authorities. But the solution to that is not an overreaction in the other direction by involving them to an excessive degree. There is a reason why the symbol of justice is a pair of scales and not a pendulum.
This one came in via email moments ago. How can we promote this policy in the diocese where we're located? Who'd like to tackle that one? David, want to take a shot at that?
Yeah, can you read the last part of it again? I got the first part, but the last part was what?
It said, how can we promote this policy in the diocese where we're located, in our own diocese?
Thank you for giving us the opportunity to plug this. I mean, our goal was not to simply write a model policy and put it on the website and say, here, we think it's good and it should be promoted. And I'm glad you asked, because the way, an easy way to do it would be to send an email or a letter to your bishop or superior and say, hey, I just sat in on this, webinar on a model policy that Melchizedek drafted. I'd like to know whether you think that the policies we have in place are addressed here. Probably kick it down to the Vicar General or somebody, but you should get a letter back of some kind that says, yes, to some extent, or no, to whatever extent, and then hopefully a conversation can start. I mean, we'd love to be able to help any diocese, religious order anywhere implement something like this. I mean, realize that there's always something unique about a particular diocese or venue with the people involved, and sometimes you need different definitions or something. But that's why this is a model policy. Is it's supposed to get the gist of what everyone should have. I mean, I'll tell you, many of these provisions came out of the Los Angeles Archdiocesan policy. We're able to pick and choose and say, that's good. I like that. That's good too. I like that too. And I'm sure you'll find these in other policies as well, but you might not find them in your policy, and you won't know until you ask. And so we'd encourage you to ask and look for it and see if you see these things in the policies that apply to you. Because if they don't, then we think there are issues.
Okay.
Yeah, I think that's great. Hold on, Paul. I also think that, again, going back to the priest, constantly asking, what is the process? Why can't they tell me the process? Where am I in the process? Those priests that are questioning that can come to our website and look at our model policy. And then they can ask their bishops, what stage of the policy are you in? Well, we don't have that stage or whatever. And they can talk about that. Lay people and other priests that are looking at, how are my rights protected, can look at our model policy and question their vicars and their bishop on is this how our process works? Because that, again, is the due process that the priests are concerned about.
Okay, excellent. Hey, actually, I'm excited because I think I can even answer this question. This one just came in. Is the model policy on the MOM website? And if not, how can I obtain it? And I believe the answer is yes. It is. We have it published on the website in PDF, correct?
We have it published on the website in a PDF form and on the internet. And we also actually uploaded a guidelines for canon lawyers and canonical advocates when they're appearing, when they have a meeting with an investigator and appearing before the review board, and even have a sample letter there that canon lawyers or advocates can send to an investigator prior to an investigation.
Awesome, great. Thanks, Joe. Another one that came in via email. On the subject of publishing lists, do you realize that the phenomenon of publishing lists of credibly accused is a widespread practice in the US? It seems unrealistic in this day and age where transparency is demanded for you to question this widely accepted practice.
Well, like I said, that topic is worth a webinar of its own, and maybe someday we'll have that. But all I can say to that is you got to look at the tradition, and you have to look at the law. Publishing the names of people who are merely accused, absent truly extraordinary circumstances, it's sinful, it's defamatory, and it's possibly criminal. I mean, having your name published on the internet as a sex offender by your own diocese or religious order before you've even had a chance to defend yourself can absolutely destroy your life. And, not surprisingly, it's led some people to totally despair. The risk of suicide is real, as is leaving the priesthood or even the church altogether. And, I just wonder, when someone in the future writes the chapter of this period of church history, I wonder how this is going to be perceived.
Yeah. All right. And we do have one more that just came in as well. What about bias for members of the review committee? Are there any provisions that would allow for disqualification of biased members? Great question.
Can you read that again, Paul? I'm sorry.
No, Joe, I'm kind of done. No, I'm just kidding. What about bias for members of the review committee? are there any provisions that would allow for disqualification of biased members?
Well, I can happily answer that.
Yeah.
The answer is no, not yet, but there will be, because we're looking at adding in provisions that will address bias of committee members. So stay tuned. That's an excellent question, and it has to be addressed. And I'll give you a simple reason for it. But as a civil litigator, I'm involved with mediations all the time, and disqualification of judges, and the rules are crystal clear. You can't be a judge in a case if you know the defendant, or know facts involved, or know the complainant, or you've had ex parte communications, as we call them. So again, taking common legal principles that are widely assumed and given, so much so that any lawyer who crosses those lines is immediately chastened for it. Why shouldn't we do that here? So we want to. I can't wait to get model version 1.1 out, or whatever we'll call it, that includes bias provisions.
And there are provisions like that in church law as well. But the issue that we face with this current regime that we have is it's not technically a trial. So a lot of people just say, oh, well, it's not technically a trial, therefore all those rules don't work. We have to back up and apply those by analogy, because there are real rights at risk in this situation. And the bias of people on the review board is an enormous issue.
Okay.
Yeah, and bishops typically will not go against their review board findings.
Yeah.
Okay. And we have another comment here. Hopefully bishops organize conferences and even talks in their diocese about false accusations. That will be a revolution, but that might not happen tomorrow. We can only pray.
Well, it goes back to what we were talking about, how that Attorney Vincent Sanzone had made a comment and question about how do we get lay people to, promote the false allegations. And I think that's really valid. I mean, how many times, I've said it to bishops when they talk to me about somebody. I can remember one bishop in particular, because it was a close friend of his that was accused in another diocese. And his friend called him and said, look, I'm on a leave of absence. He consistently professes innocence. And he said, they won't put me back to work, that they're dragging their feet. Can I do something for you? And we talked about it on the phone. I'll never forget it. I was in the parking lot after Sunday Mass. And my first question was, well, do you think he could be falsely accused? He said, well, I never thought of that. And I said, well, it'd be good if you thought about that, because maybe they're lying about your friend. Maybe he is completely innocent. And, the only way they're going to find that out is if the bishop in his diocese, your brother bishop, who you can get on the phone and talk to, does a competent, thorough investigation, which is what, we're talking about here. Find out what the facts really are. And then we can determine what the appropriate response, the bishop can determine what the appropriate response is for him. But yes, there are. I will say, in my experience, after thousands and thousands of priests, there's well over 1,000 falsely accused priests right now, out of ministry.
Could I just add a quick PS to the prior question about the review boards? It's not just bias that's the problem, and I think this model policy is a first step in this direction. Better preparation, because the review board people that I've spoken with, many of them they're not biased. They're good-hearted people who want to serve the church in some capacity, but they don't know enough about the principles that should be applied here. They don't know enough about canon law. They don't know enough about the presumption of innocence. They think, many of them, that, hey, this is the trial. This is a thumbs up or thumbs down, beyond a reasonable doubt, and that's not true. But these people need to be prepared adequately before they serve on such an important body in their diocese. So that's yet another area where we can help.
Yeah, excellent. I think we've kind of gone through all the questions, and we have one final comment here from an attendee that said, excellent webinar. Thank you, team. Open discussion and knowledge is very powerful. Thank you for those kind words. Thank you to the panel, and especially to my colleagues here who did all the heavy lifting on the model policy and their dedication and their work. Dr. Mazza, Dave Schoenfeld, and Joe Maher. You guys are true champions of the church. Unless there's any other questions, I don't think there is. I would just suggest that we close with a Hail Holy Queen, as the Blessed Mother, is the protector of our church. So let's just please join me in the name of the Father and the Son and the Holy Spirit. Amen. Hail, Holy Queen, Mother of Mercy. Hail our life, our sweetness, and our hope. To thee do we cry, poor banished children of Eve. To thee do we send up our sighs, mourning and weeping in this valley of tears. Turn then, most gracious advocate, thine eyes of mercy towards us, and after this our exile, show unto us the blessed fruit of thy womb, Jesus. O clement, O loving, O sweet Virgin Mary, pray for us. In the name of the Father, and the Son, and the Holy Spirit, amen. Thank you all. Thank you all you attendees who, many of you are still around. Thanks so much. And thank you, panel. And anybody else have any closing comments? And we'll wrap it up.
Remember, at the end of February, we're going to have another webinar specifically on going through the mechanics of a competent and thorough investigation.
Okay. Have a good evening, everyone. So God bless.